can I go this way? To the flag? Okay, I can handle it. All right, so I can roam a little bit, thank goodness. Between being Italian and who knows why else, I can't stand still or keep my hands still when I'm talking. So it's very nice to be here. Just a quick note, for those of you who may not have noticed it on the calendar, we have a pretty intensive day of risk management seminars that I'll be teaching in this room on Wednesday. We're going to be covering electronic media risks, technology problems and issues, realtor inspections, which of course is the number one source of claims against our licensees, and several other topics. I'll be actually covering 5 topics that day, and from 9 until 4 we have a lunch break. It's $20 for the full day of seminars, and you can also sign up for the whole series with Nikki and the staff. So I hope to see you there. How many of you have ever served as a director for CAR? Anybody? Okay. Let me tell you, as I guess I've been going to the CAR directors meetings 15 years at least. I work with 4 different associations of realtors, including this association, which in a way is my home association since I was born here in the neighborhood. But CAR meets 3 times a year, in May in Sacramento, and then in January and again in October. And the directors, the representatives from your board here, meet in a variety of committees and working groups, and we talk about all kinds of things, challenges to the profession, legislation, of course, is a big one, and the need for legislation. And in Sacramento, that's a particularly heavy week because they spend a day, Wednesday typically, going across the street from the Hyatt and the Sheraton in downtown Sacramento to the Capitol, where we have a big lobbying day. I typically, just so you know what I do, I can't spend the whole week. But I go up there on Thursdays. I attend the Home Ownership Housing Committee and the Investment Housing Committee on Thursday morning. And then on Friday, I attend something called the Legal Affairs Forum. Now, Legal Affairs Forum is a 6-hour session. We have seminars even through lunch, and it's all only open to CR attorneys. So, or attorneys in the real estate specialty. Not all the attorneys are CR members. Most of us are, because most of us have our licenses. But anyway, that's a closed meeting, and we spend 6 hours talking about the latest cases, legislation, and then we have special seminars. I think there were several topics that were major discussion points in Sacramento week before last. One, of course, always is what are the different bills that are working through the legislature. If you're really interested and you want to know what is CR's latest legislative update, it's pretty lengthy, but I brought about 10 or 12 copies in the back. And it goes through all the legislation that CR is involved with or watching. And you're certainly welcome to grab that. It's available on the CR online website as well. It's pretty easy to find in the legislation section. One of the topics that was interesting, sometimes these certain directors' meetings develop a theme. This time it seemed to me that the theme was landlord-tenant issues, because in the Property Management Risk Management Forum we had a presentation on landlord-tenant problems. In the Legal Affairs Forum, we lawyers had a presentation on landlord-tenant, and at least one other place, I think it was in the risk management session on Friday morning, I was told they had a landlord-tenant session. Well, landlord-tenant, there are a couple of ways that it involves all of us. Certainly when you're in a buy-sell transaction and you have the property not owner-occupied, one of the things that always is a bugaboo is we're trying to get escrow closed and we can't deliver possession to the new owner, and that can be really a problem. But it comes up in a number of other ways because a lot of our colleagues use rental management as a nice solid income supplement. And so the issues on landlord-tenant are far more than just simply can I get the tenant out on time and do I have a binding lease and are they paying rent. One of the issues, and we're going to talk about this a little bit at more length in a moment, is dealing with fair housing violations. The issues that come up in my office most often when our members call us either on the I'm on the overflow for the legal hotline as well, right? If one side of a transaction calls on legal hotline and then the second agent on the other side of the transaction calls, now there's a conflict, so there's a group of us that take these overflow calls. Well, anyway, Sometimes the overflow calls on landlord-tenant issues, they tended to group into a couple of areas, I think, for me. One is, of course, issues involving problems with the property, like water leaks, mold issues. Tenants are concerned, threatening to sue because they found some black spots in the bathroom. The other kind of issues also are fair housing. Is we get problems with tenants alleging fair housing violations or asking for things that the landlord or the rental agent, you all, may not realize triggers a fair housing request. And that wound up being a significant item of discussion on Friday with the Legal Beagles. And it's amazing the breadth of issues that where a tenant can trigger a fair housing violation. And also, let me just make sure you understand at the outset that you, when you're acting as the rental manager for the landlord, you are considered part of the landlord. And you can be held liable for violating fair housing laws just as much as the property owner. Yeah, so it's something that you really need to be familiar. Watch for some red flags in the fair housing area. Examples of red flags. When you're dealing with a tenant and they're asking for something that involves a claim of any kind of illness, any kind of mental or physical illness, or any kind of a physical limitation that they're struggling with, that is a red flag. We may have a fair housing request even though they don't know to make it in those words. Let me give you some classic examples. You have a no dogs building. Now, as in a rental property, the law allows you to have a no dogs building. As you may know, in HOAs, you can't have a strictly no dog property anymore. You have to allow people one pet. But you have a no dogs 20-unit building in Gardena, and a tenant comes in and you find out they have a dog. Usually, here's how it happens. You find out they have a dog. You go to them and say, you've got to get rid of the dog. You have a no dogs provision in the lease or in the tenant rules. And then the next thing that happens is in the mail you get a letter from the tenant and a note from a doctor or a social worker or a nurse or a therapist or a, marriage and family counselor. The list is amazingly broad. It doesn't have to be from a psychiatrist or psychologist. And that healthcare worker writes you a note that says this certifies that this person needs this animal for mental comfort. Boom. At that point, we're going to have to allow that dog. Now, we don't have to deal with problems from the dog. We can insist the dog not bite people, bark in the middle of the night, damage the property, but that's a real common fair housing issue. And it seems there is absolutely some abuse in this area, and we're going to talk about a CAR bill in a few minutes that's trying to deal with that abuse. But in a landlord-tenant situation, really watch out for those kind of issues. And I will get to your question in just a minute. Let me complete my thought. So there's one really common area of a fair housing violation. And you think of fair housing, you think of race discrimination, you think of people in wheelchairs. It's far broader than that because disabilities are far broader than just the inability to walk. So comfort animals is certainly one common request that you have to be very careful about. Also be very, very careful about restrictions on children. Many buildings and many condo associations, frankly, have restrictions that say children are not allowed to play in the common area, or children can't play on the landings, or children can't do this. Anytime in an HOA or a rental property you have something that singles out children specifically, you're violating the fair housing laws. And let me tell you how messed up this is, because it is. There are conflicts in the law right now that are unresolved. You probably know, if you ever manage a property with swimming pools, that there's a state law. It's in the Title 24. It used to be in the California Health and Safety Code. But in Title 24 of the California Code of Regulations, there is a long-standing requirement that swimming pools have a sign that says, and if you haven't seen one of these, you've never been to a pool, that children under the age of 14 should be or must be accompanied by a parent. I think it should be accompanied by a parent or guardian. Now, that's state law. Okay? You have to say that. But guess what? Can you adopt a rule in your apartment building or in your HOA that children are not allowed in the pool without a parent or guardian? No, that's actually a violation of fair housing. Is that really sensible? Absolutely not. That makes no sense. So you have to put up a sign or you violate the law, but if you take any steps to enforce what the sign says, you violate the law. Yeah, welcome to my world, okay? So I'm hoping at some point that will be fixed. And the reason why I bring this up is, as soon as I mention restrictions against children, many of you think, wait a minute, I see those signs that specifically say children under the age of 14. Okay, that is a little teeny tiny anomaly in the law, and it's unresolved. But other than that, in your tenant rules, in your HOA rules too, for that matter, you can't single out kids. If you don't want people playing in the courtyard, then just say no play in the courtyard, whether you're 25 or whether you're 5. Okay, so that's another real common area of issue. Another area that goes back into that it's also fair housing relates to allergies. Now, my view, just as a practical matter, is that any wood frame multi-story apartment style structure should just not allow hard floors, period. Because you can't make that building quiet. The only way you're going to get quiet between upstairs and downstairs neighbors if you're in a steel frame with concrete deck structure. All right? If it's a wood structure, even with carpet and pad, you're going to hear footfalls, right? Many of us have lived in apartments or condos. That's part of the package. Well, guess what happens when people want to upgrade their apartments to a hard floor, tile or parquet or all these different nice hard materials? Well, of course, the landlord or the HOA says, well, no, wait a minute, you're creating a drum for the people that live right below you. Every time your little child's heel hits, not just an adult, every time your dog's paws hit the floor, they're hearing that noise below, and it really exaggerates the problem. Well, so what do is we say, we have a rule that you can't have hard floors in your apartment, okay? Well, that sounds pretty simple. Everybody's got to have carpet and pad. But then you'll have people that will come to you and say, and they don't always say, by the way, before they put the hard floor in. A lot of times this comes up after it's in, and now they're coming up with a justification. True or false? Anyway, you get a letter from, again, doesn't have to be from a general physician. It doesn't have to be from an allergist or a rheumatologist or somebody who deals with allergies for a living. Oh no, it could be from a social worker. It could be could it be from a Chinese herbalist? Probably. A marriage and family counselor, absolutely. The definition of health care professional in California law is extraordinarily broad right now, and there's no sign that it's going to be narrowed anytime soon. So then you get a note saying, my client Richardson has to have a hard floor because he has severe allergies. Boom, we're done. Game, set, and match. Now we're going to have to allow a hard floor. Does that mean we have to allow any floor the resident wants? No. Because we are required to allow reasonable accommodations, not any accommodation. So typically the battlefront in those at that point changes to, all right, we're going to, of course, allow you to have a hard floor, but you can't destroy the life of your neighbor below. So now we're going to talk about some sound buffering materials that are going to go underneath that floor, underneath that tile or wood, whatever. So those are three of the things that I see in my office most often. Children, hard floors, and pets. Those seem to come up the most. From time to time, we do see occupancy issues. I don't see those alleged against my property owner clients or my landlord clients as much as I see my clients dealing with situations in their apartment buildings or their condos and wanting to have occupancy limitations. You've rented out a 3-bedroom house. You find out there are 12 people living in that house. Are they violating LA County, LA City, or California state law? The answer is no. Nope. I have researched until the cows come home. I still can't find any city, county, or state law that limits how many people can live in an already completed structure. There are building codes that talk about the intention and how large you have to build rooms and bathrooms and what have you, but there's no occupancy limit that automatically binds. So what happens is then the landlord or the HOA board's next question is, well, I want to pass a rule that limits the occupancy of children. I'm sorry, not children, the occupancy limit of people in the residence. And typically what we would probably immediately go for is we say, well, first we want to have it occupied by single-family use, right? We use that term all the time, single-family home, okay? Little problem here. In the fair housing world, the definition of single family ain't what you and I think it is. The definition of single family has nothing to do with a marriage ring or genetics or a domestic partner agreement. A single family occupancy is defined in a couple of major cities, including San Diego and I think LA, as a group of people sharing a given residence. That's all it means. If they're sharing facilities inside the residence. So we have 6 college kids sharing a 3-bedroom apartment. If they're sharing the kitchen, the living room, the bathrooms, okay, they're sharing common facilities inside that dwelling, that is a single family use. So if you're a landlord and you're worried about, well, wait a minute, they're not really a family, good luck, because the definition is far broad. Basically, the only way you can violate single family occupancy is if you subdivide the property and you actually carve off and say, okay, guess what, the kitchen is now walled off to this person and that. And then let me finish thought, and I'll get to your question, because I just want to get through these 4. Anyway, so what happens is landlords want to limit the number of people per bedroom. That's kind of natural. And how much would you think would be a normal limitation that kind of makes sense to you? In a 3-bedroom unit, how many people you think should be fairly expected to be the most that could live there? 2 per room, 6? Yeah, right? We all pretty much, boom. If we took a poll, 90% of us would say 2 per room, right? 3 couples, no problem. Or 3 roommates or whatever. Okay, that violates fair housing. Yeah, well, I was right. And what's really hard about this is it's not written down anywhere. Because the fair housing laws say that you can't discriminate against familial status. That means whether or not you have children. Well, the idea on the occupancy limits is if you're 2 per bedroom, you're now too strict. And the unwritten law, and you won't find this written down anywhere. Believe me, I've tried. The unwritten rule in California is that the most strict you can be is 2 per bedroom plus 1. So in that 3-bedroom apartment, the maximum, the smallest you can limit would be 7 people. Okay? Now, there's a reason why I mention this, because we're going to talk about this in a few minutes in terms of the fair housing regulations. But so when you have an apartment limitation or a condo limitation or a rental house, that 3-bedroom house, the smallest number you can limit occupancy to is 7. 2-bedroom, 5. 1-bedroom, 3. You with me? 4-bedroom, 9. Okay? So those are the things that seem to come up most often in my practice, where I'm asked by landlords or sometimes brokers, property managers, what we can do in the fair housing area. And you were very patient. I'll go ahead and take your question, and then, ma'am, I'll take your question next.
When you were talking about...
I'll repeat the question, Nikki.
Okay. When you were talking about service dogs, or what I thought were service dogs, they had to be, given a stamp of approval by some organization, and I don't even know what, but the common language that we always used was we have to allow service dogs. You're saying all a person has to have is a note from mom?
Okay.
So, from the doctor, that's it?
So the question is about service dogs, and all we have to have is a note from mom, and that's kind of it. Well, there's a terminology issue here, and I frankly can't remember if I wrote this article for South Bay 2 months ago or if I wrote it for my newspaper column recently, but the difference between service animals and comfort animals, there is a big difference. I'm talking about comfort animals. A comfort animal does not have to be trained. It just has to be confirmed by a healthcare professional that the person needs it. A service animal is very different, and that is a dog that actually under federal law, this is going to blow your mind, a service animal under federal law is either a specially trained dog or a specially trained miniature horse that has been trained to perform a specific task or function. That's a service animal. And you're going to find that even lawyers, when they're making the threatening letters for their friend, okay, because usually they're helping a friend out, they're not getting paid, but sometimes they are, when they will say, my client has a right to a service animal, and they attach a note from a doctor. Okay, they're using the wrong term. They're asking for a comfort animal. They're still going to get it, but we need to know the difference. A service animal is a specially trained animal. A comfort animal is just an animal that, yes, they get a note from a healthcare worker, and that's it. Yes, ma'am, your question.
So if the landlord has on the lease that, section on the lease that typically says leave the
Okay, so the question is, in the lease, we have the tenant specifically designate who's going to be living in there, and then later on we see there's like 9 or 10 other people that move in. Can we do something about that? And the answer is, under fair housing, if we try to limit them below the 2 per bedroom plus 1, we're going to have problems. So whether or not they designated them, fair housing would not stop you from saying, wait a minute, this is a 2-bedroom apartment, there's 10 people in here. You're going to have to pick which 5 are going to live in here. Okay? So the occupancy standards are a little bit different. There may be other reasons why you can say, well, but you specifically agreed these people are going to be living, you didn't inform me, pick which 5 in that 2-bedroom. That may be the way you'd handle it. So anyway, yeah, do we take 2 more questions, and I want to move on because I'm trying to finish at 11:30, 11 o'clock for y'all. Yes, ma'am.
Quick question. In a situation where you have an upstairs tenant with hardwood floors, and the downstairs owner suffers through constant noise, the owner of that upstairs unit can't say, there's health reasons I have to have hardwood. Is there any recourse for the downstairs person because it's occupied?
Okay, so the question is, we have an owner, I guess we're in a condo, we have an owner downstairs and a tenant upstairs, and the tenant upstairs has a hard floor that's driving the owner downstairs. Crazy. Okay, first of all, in the world of fair housing, owner doesn't really matter, it's the resident that matters. So a resident is the term here. So whether or not the person's an owner, they say, I need a hardwood floor. The issue here is, I think we as landlords have a responsibility to make sure that when somebody submits a fair housing accommodation request for a hard floor, that we make sure they have some suitable dampering underneath that. And what'll happen, folks, is you'll get this, is somebody will have a floor put in violating your house rules, your tenancy rules, and then when you catch them on it, then they'll immediately rush out, and I'm sorry to sound so cynical, I'm a big believer in fair housing, big believer in ADA and fair housing, but it makes me very angry that there are people that abuse this and use it as a tool, and this is one of those things, they will, after the fact, go get a letter from a doctor saying, oh, my client has allergies, okay? And the doctors think, oh, it's just a note, right? There's no liability for me, so they just go ahead and give it out. And the problem is that they've already put in a floor that's not sufficiently dampered to protect the people below. So that's where we get in these battles, is trying to have the tenant, the resident take out that noisy floor and put in a quiet one because they don't want to do that. And then things get really dicey. So I don't have a quick answer to that one. So let me just talk about, so in terms of landlord tenancy, that was a big topic at Sacramento a week before last, and we had a lot of discussion of fair housing. Frankly, was most of the discussion, because that's really where a lot of us are really struggling, because right now the law doesn't give us much guidance. We have one case in California called Auburn Woods, one reported appellate case to give us guidance about fair housing. Otherwise, we have anecdotal stories from press releases from the Department of Fair Employment and Housing, or we have a couple of United States District Court cases that are published in the federal reports that talk about fair housing cases that were filed in the United States District Court, and then the judge would issue an opinion that happens to wind up in the books. By the way, that's where the cases came about that are reported on the children in the pool thing. Yes, the judge says you have to have a sign, but no, you can't actually have a rule keeping unattended children out of that pool. So that creates some ambiguity. The other issue that was really interesting, and in the area in which we're standing right now, or sitting right now, this was really horrifying to me, is we had a presentation from a lawyer who specializes in working with the California Coastal Commission. And the title of his presentation was Hidden Encumbrances. And so I was thinking, all right, this will be an interesting sort of discussion of title and some of the anomalies in title. But really about 90% of it was talking about the difficulties in dealing with the Coastal Commission and the special environmental issues that can arise. And it was really interesting. Have any of you had to deal with a client trying to develop a property and get permission of the CCC? You have? What, was it fun? It was easy? Okay. Were they actually developing the property or doing something minor, or what?
We were setting up the groundwork so we could sell the property and be able to have a better path for the potential buyer.
Okay.
And I had to talk to the head of the Coastal Commission
Okay, so we had a piece of property that was just being ready for sale, and there was some registrations, some permissions, but you weren't actually developing the property at that point. Yeah, Jack Ferris.
Yeah, I was helping with development survey. It took us 7 years. Plus all kinds of.
Yeah, the guy. Remind me the name of the developer. I've met Jim York. I've met him many times. I've talked to him. You got to admire Jim York and his persistence, right? I mean, how many people would fight 7 years? And then, of course, when he finishes it, half the golf course hole slides down. Remember that? Yeah. I actually talked to the guy who was on, a little digression, I actually talked to the guy who was on the fairway with his dog when that thing dropped down about 40 feet. He was unhurt, except probably the wet pants. Yeah, they had to get the firemen and get him and the dog out of there. But yeah, remember that was a great story. Anyway, so the point of it all that was terrifying for us attorneys is that the California Coastal Commission has jurisdiction that varies depending on where you are. In an urban area, the Coastal Commission's jurisdiction may only be a few hundred feet from the water. But in rural areas, I think they said it can go up to like 3 miles from the water. So really broad jurisdiction. And I don't know if you've been following the LA Times lately about the California Coastal Commission. They're not doing too well right now. They have some issues. Well, this seminar was before I read about all the controversy with the CCC. But one of the things, if you're dealing with a property that you find out is subject to California Coastal Commission jurisdiction, be really, really careful. There are stories that we were told not only about environmentally sensitive areas that are designated as such, but there's also a category of unpublished environmentally sensitive areas. So you have to go check with the city or to find out if this is not only a published environmentally sensitive area, but if it's an unpublished, a non-registered area. And there actually is a category for that under the regulations. So there was a story of one person who was trying very hard to develop a piece of property very close to the water, and he got very far down the process. He was told that the property was free of any environmentally sensitive designation. He was even told that it was free of any unpublished designation of sensitive area. And so he went on for a couple of years, spent 6-figure money on it, and then the local jurisdiction decided to declare that area an unpublished sensitive area. And I think I have the term wrong. And that completely destroyed his ability to pursue the property. The other story that we were told was somebody who was taking a house, an existing home, on the sand, and they were going to build a new house on the same lot. There's already a house there. And the California Coastal Commission said, well, we'll let you do it, but only subject to a covenant that every square foot of the property that is not covered by the house will be a public dedicated easement. Oh, you have a problem with that too? Yeah. So it was really shocking, and I think most of us in the room, if we'd been asked to take an oath that we would never ever tangle with the CCC, I think you would have 100% participation. Yes, I swear I will never get those ulcers. It's a very. I know that the Coastal Commission deals with very important issues, and our coastal zones are precious, and that's one of the things that makes California special. But in terms of red flags, you really need to make sure. Frankly, you have a California Coastal Commission issue, and you call me up, guess what? I'm going to bring in a specialist. I mean, when I have environmental situations from time to time and we need a CEQA challenge or something, I almost always bring a specialist in that particular area to help me out. And that was one lesson I think we all learned, is that you have to be very, very careful if you're within California Coastal Commission jurisdiction. So those I think were the big issues that I thought were interesting. There's always a ton of things at the directors' meetings about form changes, and you get lots of updates and all of that. So I'm not gonna use your time that way. One of the things in terms of what's coming, I want to give you a couple of highlights of things that are headed your way in terms of the area of law. Certainly, CR has a number of bills working their way through the system this year. CR has a pretty darn good track record. When we ask for something in Sacramento, we usually have a pretty good success rate. About in the October meetings last year, the investment housing? Investment housing committee members started talking about the difficulties in so-called comfort animals. And the vote was taken to pursue legislation to somehow give landlords guidance in terms of what is a comfort animal. And I'm all in favor of that, but there's a little problem when we get into the area of fair housing is we have federal and state law. So we can change the state law, but we still have the federal law to deal with. Well, CR sponsored a bill, AB 2760, and if you're really interested in this, I brought about 15 copies in the back. And this is still working its way through the legislature, and it's trying to give some guidance as to the difference between service animals and comfort or companion animals. And it's been, for practical reasons, it's been diluted a little bit. It doesn't do quite as much as I think some of us were hoping. But it at least for the first time says some things in its current form, in the form that as we stand here today in May 2016, it would require that the tenant notify the landlord first before bringing the animal on. It would require that the animal be housebroken. And this is really a big deal, that the animal can't disturb the quiet enjoyment of the other residents in the building. Isn't that logical? But you know what? There's no regulation on the books anywhere that I can point to a judge and say, Judge, a reasonable accommodation is not something that disturbs the other residents. So this bill, if it makes it all the way through the legislature, would do some very helpful things like that. So that's AB 2760. Well, to me, the most interesting parts. It does a number of things, but at Section 2 of the bill, it says first that the tenant has to let the landlord know that that they're bringing the support animal onto the premises. 2, that the animal be housebroken. 3, that the animal can't disturb the other tenants or threaten the other tenants. And 4, that the presence of the animal can't jeopardize the availability of insurance for the landlord. So some insurance companies, I'm told, won't allow you on your property to have pit bulls, for example. Yeah. So your tenant brings on a pit bull and says this is a comfort animal. Now, I love dogs. I have 2 dogs. I just never really see the pit bull as a comforting, cuddly thing. I don't know. Maybe I'm prejudiced. I'm sorry. Okay. I lost somebody in the crowd already. All right. Well, there's one bad review coming. I'm very sorry. Yeah. Yes, ma'am.
All of these have to do once the tenant is in. Let's say my client, you're helping the client with the lease, and they would prefer no pets.
Right. Well, so the question is, the landlord prefers no pets, or a neighboring tenant would prefer no pets in the building?
No, it's just that I'm going to lease my property, I'm going to put it on the owner, we don't want any pets.
Okay, great question. So let's say it's a single-family home. We're not even an apartment building. We're a single-family home, and I want to rent it out as the owner, and I don't want any animals in my house. Can I do that? And the answer is no, you can't do that. If somebody has a disability and they present you with a letter from a licensed, not licensed, a health care professional is the term, you have to allow that dog or cat. Can you place conditions? Right. You can say, well, fine, but that animal can't disturb the neighbors, it can't damage the house, it needs to be, there's some things like that you can insist, but you cannot have a blanket statement, no animals. You can say in your advertisements, no animals, okay? But when somebody comes to you and says, oh, well, I have a comfort animal, okay, you're going to have to allow that.
No pets is okay, except for the exception.
Yeah, the question is, no pets is okay, yes, but you have to be prepared to make an exception, just like you can't have hard floors. If somebody presents a disability, you may have to work with them to have a reasonable accommodation. Yes?
When it comes to a service animal or a comfort animal and the lease is, and this landlord doesn't want pets, can you ask for a deposit once they stay?
So somebody wants to have a comfort animal on an otherwise no pets building. Can we ask for deposit? I think that's a touchy area. I'm not sure. Because we need to be, okay, this is just us. I think this recording is just within our members, okay? This isn't going to go anywhere. We need to recognize that the legal environment in this area is very much anti-property owner. the legal environment is very much disposed in favor of the person asking for the accommodation. So whether it be the ability to smoke medical marijuana, or have a hard floor, or have a comfort animal, or whatever, we need to be very cautious about doing anything that might sound like we're trying to discourage the accommodation. So I'm not sure. I've told a number of clients, is the deposit that important to you? I mean, it makes sense because we may have to do some extra cleaning of the carpets because Fido occasionally is going to make a mistake, right? So I think that's one of those maybe. Yeah. So the other thing that's interesting about this bill that still may be a problem is I told you that it says the residential lease may require a tenant to first notify the landlord before they bring the support animal on. I find no support for that in the fair housing laws whatsoever. Okay? If I forget as a tenant and my counselor, let me go real mainstream, my psychiatrist says that I need Fluffy for my stability, then the fact that I didn't tell the landlord up front, I don't think that's going to affect my ability to still invoke the Fair Housing Act and say you've got to allow my cat or my dog to come with me. So I think there's a part of, my guess is we're going to see that bill's going to change a little bit more. Because again, and this is why it's already been watered down quite a bit, is we're struggling with a very anti-landlord environment on this issue. Okay, so I'm not sure. I could almost guarantee you this bill will not ultimately become law in exactly this form. I think it's going to have one more mutation. Yes. Well, see, it's okay to discriminate against pets. It's just not okay to discriminate against comfort animal pets.
But I'm saying, these before those people came and said, I have a comfort dog or I have a service dog.
Yeah.
And you picked number 5 that has no dog.
Yes, if you know in the application they tell you I have a comfort animal, and yeah, you better not be caught deliberately avoiding that tenant when their credit was better than everybody else, and right, that's bad. So again, you can ban pets. My guess is what I would do in the application is I wouldn't ask if they have pets. I would just say, I understand this is a no pet building. Okay? So that way you don't know if they have pets and you don't know if it's a comfort animal. But if they in that application say, well, I do have a comfort animal, but I'd really like to rent your house anyway, you better be darn sure you can prove why you picked somebody else, if that's what you're going to do. So, yes, sir.
Is there anything we can do in here about getting a licensed healthcare professional as opposed to just the internet healthcare professional?
Yes, yeah. And the question is there anything we can do to get a requirement that somebody actually has to have the appropriate license in that area instead of just anybody that fits in this broad field? And that is a huge problem right now. And the answer is right now the law doesn't impose that requirement. I see all the time a resident who has got a hard floor without permission or brought in a dog and got caught at it. The first thing they do is they go out and get their college buddy, who may be an orthopedist, okay, writing a letter saying that my patient needs a comfort animal. I'm sorry, but I know it's really hard to get a medical license, but I don't think that the Fair Housing Acts were thinking about orthopedists talking about emotional well-being. Orthopedists would be talking about my clients having difficulty walking, right? But that's the problem we have. It's very, very broad. So that's a nice transition, though, into the other thing that's going on right now, because the fair housing laws in California are very, very much in flux. As far as I've been able to tell from my research, there are no states in the United States that really have a developed body of law to help us all understand the do's and don'ts. We lawyers that are trying to keep our clients out of trouble, we just have anecdotal information. We have press releases from the Department of Justice in the United States, Housing and Urban Development, or the state of California to know what kinds of things will get you in trouble. And typically, not always, but typically they're pretty extreme cases where most of us would agree the conduct is egregious. I mean, such as about 7 years ago, there was an HOA in Oceanside, a condo. They had common parking, and one of the homeowners was terminal. He was dying, and he needed a special van to be able to get around. And that van, he built himself, or a friend or somebody built him a little kind of crude wood ramp, so he'd get his wheelchair into his disability van, so he could try to live as normal as he could during the last months of his life. Little sympathetic situation here. And of course, what the HOA president did, genius, is he sees this ramshackle ramp in the guy's parking space and says, well, this isn't with HOA approval, has it thrown away. You know, if you're going to pick on somebody, please don't pick on somebody who is documented as dying, okay? That's just not going to go over well with anybody, and it didn't. And the Department of Fair Employment and Housing fined this HOA, I think it was $150,000, okay? And you have to pay the other side's attorney's fees, too. Never went to trial. That was settled. I mean, those are extreme cases. Do I think any of you would kick the ramp away from a dying tenant? I hope not. You all look like decent people. But the problem we have as lawyers is all we have are those extreme cases. Here's a situation I'm dealing with right now. I won't tell you where, but here in Southern California, I have an association that has a 2-dog limit. These are detached homes. 2-dog limit. Nothing wrong with that. A homeowner has 3 dogs. The HOA busts him. You got 3 dogs, sir. Guess what he comes up with? A letter from his therapist, and at least he got from a psychological professional, saying that my client needs this 3rd dog as a comfort animal. And so I've now received 2 lengthy letters from this guy's personal attorney, and from a pretty darn good law firm, telling me that the law requires that we pretend that dog doesn't count, because it's a fair housing accommodation. It's a comfort animal. So that because of that, it's a free dog, and so they should be allowed to have 3 dogs in their home. And the board of directors and I are trying to struggle with, okay, is this a battle we want to fight? You know, we don't know. So let me, because I want to get a dual agency, and I've got 34 minutes left. I'll take questions at the end as long as you all want to stay. I know it was advertised till 11:30. I like to set a goal and then get at least close to it. So what's going on for about 2.5 years now? Let me give you a little background. We have something in California called the Fair Employment and Housing Council. This is a group of 7 people appointed by the governor, and most of them were all appointed by Governor Brown. The Fair Employment and Housing Council's job is to create and review and amend fair housing and fair employment regulations for the state of California. There is a separate agency in California called the Department of Fair Employment and Housing that actually enforces fair employment and fair housing laws. Now, the councils has developed a number of pretty complex and detailed regulations guiding employers on a variety of things like disability, pregnancy leave, and other type of job discrimination issues. Right now, they're struggling with transgender adaptations for the workplace, you know. But they haven't done really anything to guide our clients in the area of fair housing. We have just nothing. So 2.5 years ago, the council, which by the way consists of no real estate lawyers, the council consists of 4 employment lawyers, 3 plaintiff, 1 a guy who was general counsel for a large business, and then 1 lawyer who's a rent control lawyer from the Bay Area, another law school professor, and then the 7th member is a disability rights advocate. So there's nobody on the council speaking for property owners. It's not great, but that's how the governor appointed these people. So it's extremely, and again, this is, please keep this in the family, Nikki. It's extremely, extremely left-wing. Okay, it's really, really left-wing. Anyway, 2.5 years ago, they started a project to create fair housing regulations for the first time of any state, as far as I can tell, in the country. The first draft they came out with 2.5 years ago was created by this employment lawyer and by the rent control lawyer. At that point, they had nobody with any real estate experience on the panel. They actually had 2 vacancies at the moment. The process has completely fallen apart because after the first draft was issued 2 years ago, almost to this date, the the people that were on the work group that created this draft said publicly in a hearing, because this group meets about every 6 weeks around the state, they said, we're not comfortable doing this. We need some real estate law input. Can we somehow open this up to the public? We need input from the real estate world. We don't know what we're doing. And I was in the room when that was said. They kept going anyway. So 2 years later, what we now have is the third draft of fair housing regulations. And if you're interested in this, it's kind of, it's a little heavyweight reading, but if you kind of skim through, you can kind of get the high points from it. If you go to dfeh.ca.gov, Department of Fair Employment and Housing, dfeh.ca.gov, and then you look at, that's the homepage for the Fair Employment and Housing Department. On the lower right, it has commonly used links, and you'll see down there on the lower right with the commonly used link, a link to the Council, Fair Employment and Housing Council. And if you click on that and you look at their April meeting, you will see in their April meeting, the meeting that just happened in Oakland, you'll see the latest draft of the regulations. Now, what's really interesting about the regulations is that not what it covers now, but what it doesn't cover. Originally, the draft that came out 2.5 years ago basically looked like they took some employment regulations and moved it across, and that didn't work. But they had, for the first time in this draft 2.5 years ago, they had that 2 per bedroom plus 1 standard. They actually put it in writing. And I attended 2 or 3 council meetings where, in public comment, housing rights advocates railed against the council, saying 2 per bedroom plus 1 is too strict. You need to allow much more occupancy because you have an obligation to protect marginal people who may need to pack a lot of people in those apartments and homes. And they got a lot of pressure. And they held firm for a number of months. But in the current draft, they've dropped the 2 per bedroom plus 1. It's not even mentioned. Okay, so there's a battleground that we in real estate can really help, because I can't find too many people that would seriously argue that 2 per bedroom plus 1 is too strict and is really a secret discrimination against children. Okay, but that's an issue that dropped off the draft. Another issue that dropped off the draft probably was a good decision. The regulation 2.5 years ago proposed that there be an absolute protection for people's right to smoke medical marijuana in their home. So you're on the 2nd floor and you open your balcony window and a big cloud of dope smoke comes up into your door, and you can't say anything about it because the fair housing regulations say they have an absolute right to smoke the medical marijuana in their home. That dropped out, which is good, I think, because we've still got some struggles there between the anti-smoking movement, which continues to roll in our state, and the medical marijuana movement and the legalization movement, which has made some progress in the West. The 2 things that are covered right now, one thing is harassment. Now, in the workplace, you know that in your brokerages, that if an employee of the brokerage makes an unwanted sexual advance against somebody else, the boss is supposed to do something about it, right? We want people to be able to work and be professional and not feel uncomfortable, right? Okay, we all know that in the workplace. The draft regulations still today have a requirement that the landlord, and the landlord includes the manager, take reasonable precautions, take reasonable action to respond to unwanted sexual advances in the housing development. So wow is right. So imagine this. Jack, you're managing a 150 apartment building on the Strand, and a homeowner comes into your management office at 3 o'clock in the afternoon and says, you know what, I'm really upset. I was just at the pool, and this Richardson guy asked me out and commented on how good I looked in my Speedo, and I'm uncomfortable, and I want to know what you're going to do about it. Now, right now, in the current law, you would laugh and say, well, handle it. You're an adult. Okay, don't go out. Okay, under this regulation, if it's adopted, the manager of the building, or by extension the HOA board, and the owner of the property would have an obligation to respond to that unwanted advance. What are you going to do? You're gonna tell them that I'm gonna break your lease because you made an inappropriate remark, or you asked somebody out, or invited them to your home for a drink. Huh? What about in an HOA? We're going to tell you just forfeited your condominium because you hit on somebody in the community room or in the parking lot. So I can't explain why that's still there. I testified twice against that so far, but that's still in the regulation. So there are what they did was you'll see that they issued a sort of a fragmentary regulation. They've still got the harassment thing. They took out the 2 per bedroom plus 1. They've still got some basic restrictions against discriminating against in housing for any of the protected classes. So it's very embryonic. I mean, here are the kinds of things that I think you and I need in those regulations. We'd like some guidance, for example, on medical marijuana. We'd like some guidance on can we require that people take reasonable precautions to deaden a hard floor. We need to know. We need protections about companion animals, comfort animals. Somebody needs to tell us, if I have a 2-dog building, can they get a 3rd dog and call it their comfort animal? Is that allowed? We don't know. The 2 per bedroom plus 1. We need some guidance on that. And we also, I would like to have some definition about, it's crazy to me that a cardiologist could issue a mental health companion animal prescription. That just doesn't make sense. Any more than it would make sense that an allergist would write a prescription saying that my client has heart problems and can't climb stairs and he needs to have a one of those lifts, those chair things, going up the stairs. So we're really kind of back to square one in this. I'm urging all the folks that are interested in the development. I really think that however these regulations come out, they will affect what you and I do as managers and experts helping people buy and sell properties. I think it's going to be one of the 2 biggest changes in real estate in the coming years. I really do. It's going to affect how we do what we do. So your broker, your lawyers, CAR, I'm encouraging everybody to really monitor this and be involved, because I will tell you, having been to probably 8 or 9 of these meetings over the last 3 years, the only people that show up are plaintiff employment lawyers and disability and housing rights advocates. I never see a lawyer saying, I represent 500 landlords in LA, or I represent this condominium interest group. They're not showing up. So I show up, I'm like a unicorn. I say, yes, I'm here, I'm a broker, I'm with CAR, I'm with CAI, and I really have some issues I'd like you to consider. And then I sit down, and then the line keeps going of the advocate. So that I think is going to be a huge thing that's in progress. And if you are interested in this area, I would really encourage you to start following that. The other thing that's going to really affect, I think, real estate is dual agency. Dual agency is under attack. Okay, dual agency. Let's again. This is just family talking. It's great if you're able to get both sides of a transaction where the buyer and the seller are pretty much in agreement, and you can just shepherd the transaction through, and you're able to get both sides of the commission. That's wonderful. That's not really what I'm talking about. We know that when we're in those situations, we have to be very careful to be impartial and not advocate for or against either side. And just last year, I had a commercial transaction where I had a commercial broker, multi-million-dollar piece of property. My client, the buyer, got cold feet, had some issues, didn't want to continue with the transaction, and the broker was strategizing with the seller on how to handle my client. And unfortunately for him, the emails wound up getting forwarded accidentally to my client and therefore to me. And I saw this person in writing talking about how to handle the buyer and how we can keep the transaction together, and just completely conspiring against one of his 2 clients. Oh my God. If you're going to breach your ethics, realtors, if you're going to completely betray one of the 2 sides of the transaction, can you try not to do it in writing? Okay? But that goes on. I mean, let's not pretend. There are people out there who are so focused on the commission that they forget their ethical requirements. And you worked pretty hard to get the license you have. I know it wasn't easy for me to get it. And I'd rather not lose either of my licenses just because of one transaction. But I'm not going to talk about that today. What I want to talk about is the bigger issue. And as real estate, and we all have seen the rise of these multi-branch offices just in our careers, where we have hundreds and hundreds and hundreds of agents in 6, 7, 8 offices or more, all working under the same brokerage. Okay, so here's where the attack lies. Couple of true stories. One happened right here in the South Bay. It's a reported case. About 7, 8 years ago, we had an agent see a property in Palos Verdes that it happened to be the realtor was a guy. Looked at a property that he thought, man, he'd love to sell that. And so he met with the owners and tried to convince them to list the property with him. He did a walkthrough. He saw some issues that he made a couple notes about. There were some cracks or something. And he didn't get the listing and he forgot about it. Fast forward a number of quarters later, and somebody else got the listing. And his client, his office, a different agent in his office, unbeknownst to him, wound up, if I recall correctly, was the selling agent. Now here's the problem. Is the knowledge of the one realtor that visited the property and saw the cracks was what we call in the law imputed. Imputed means it's like assumed that the other person also knows. It was imputed to the other member of that brokerage. And so the appellate court in a published opinion said, well, we think that brokerage could be held liable for breaching their responsibilities to the buyer or seller because this information was not passed along. Now, in the legal world, we understand this kind of a concept because we have even more strict conflict of interest policies. And so we all have software that when one of your clients calls me for a consultation, they go into a system. And we have a record that 8, 9, 10 years later, somebody else calls us up and they say, I've got a problem with that person. Well, our computer pops up that name. We know that somebody in our office has dealt with that person 8, 9, 10, 15 years before. I don't think we have that in organized real estate, at least not that I've heard of. Well, yeah, we don't charge by the minute, right? Well, but the problem is when we had small offices and technology was fairly limited, this wasn't a big deal. But now we have massive offices. We have extremely huge amounts of data being collected and saved, and the problem becomes much more acute. And that's really the issue here, is that in the large office, you may not even realize that a colleague of yours got the listing a year later, but yet your knowledge is going to be imputed to that realtor in your office you don't know. Yeah, I mean, this is a reported case where this was held. Clearly, the other agent didn't know, but when the plaintiff was suing for problems with the property, somehow, and I don't know how this came out, frankly, somehow they found out that this other person had been on the property and somebody connected the dots. So the other issue, this happened in my office. There was a large brokerage sold a very gigantic home in a very upscale community somewhere in LA County. Millions of dollars home, 10,000 type square foot house, gigantic, amazing property. The house had been built by the seller, and a very large brokerage franchise landed the listing. A different agent in the same office, who didn't even know the listing agent, it was that big an office, wound up representing the buyer. So during this transaction, there was a discussion. Now remember, brand new mansion. The seller in the RPA gives a builder's warranty, 1-year builder's warranty on the house. Now nobody really defines what that means, which by the way is a problem, folks. Okay, you got to define what's warranted. And anytime that comes up, just a little side note, when you're talking warranties and what a seller should warrant on a house, that's a classic moment. You want to turn it over to an attorney for a quick consultation, okay? It doesn't have to be me. It could be somebody down here. You've got some great real estate firms right in our backyard here. you really at least need to recommend the client have a lawyer talk to them a little bit about what warranties they should or should not give and how they should be worded. Chances are they're not going to follow your advice, which is why you're going to want to put this advice in writing. And then you keep going. Anyway, back to my story. So this seller and this listing agent did not do that. They just had a one sentence in the RPA, 1-year builder's warranty to apply. So, of course, the transaction closes, and within a matter of months, we have sewage floods in the downstairs bathroom. We have things cracking. We have leaks. The air conditioning doesn't work. And so my client puts in a demand for warranty repairs. Well, that the seller says, well, wait a minute, I didn't warrant all that. Well, the buyer and seller are off to the races now with a lawsuit. The next thing that happens is the seller turns around and sues the listing agent, saying that you had an obligation to protect me and that your office was dual agent, and so you should have not told me to issue a builder's warranty of any kind. And you also didn't protect me because you didn't explain it. Now, these two agents didn't know each other. They were on probably opposite sides. I don't even know if they're in the same branch of the brokerage. They were in the same general area, but the knowledge of the one was held to be imputed to the other. It was held to be a dual agency. Now, it was resolved privately in arbitration. My client and I weren't part of it. But that case went all the way to an arbitration trial, and that seems so unfair, doesn't it? I mean, how can I be held to be a dual agent when I don't even know this colleague across the office, or I may have met them at an event or something. I may have seen them here at a South Bay event. So we're seeing some real challenges now as the rise of these large multi-branch offices and technology are really colliding with dual agency law. And I'm going to tell you, just the general public doesn't like dual agency at all. They really don't. They think we're being greedy. They think we're playing both sides of the fence, and they think that our loyalty in a dual agency situation is to one thing and one thing only: the closing. I mean, we got to be honest with each other, okay? So I know that dual agency isn't going to go away, I don't think, anytime soon, but it really creates a delicate situation for you all, and it really calls for some restraint. So let me talk about this case, and then I'll open it up for questions, because I know I'll try to answer what I can. There's a lot I don't know right now. The case called Horiki versus Coldwell Banker. This case is currently pending in front of the California Supreme Court. So the court's going to do something on this, and we don't know what. This case, I've got a little quote here from the case. Okay, sounds familiar. Cortazzo, an associate licensee acting on behalf of CB, had the same fiduciary duty to Horiki as CB. Now, here's the problem. This is a nice property involving a Coldwell Banker agent out in Malibu and a Coldwell Banker agent in the city of LA. Many, many miles, totally different offices, but still under the Coldwell Banker overall brokerage. Turned out there was about a 3,000 or 4,000 square foot discrepancy between the listed advertised size of the house and the as-built size of the house. And the knowledge, Horiki's lawyer said, well, now wait a minute, you should have disclosed this to me. Well, Horiki's agent didn't know the listing agent. But the listing agent was held to have a responsibility to disclose to the other side of the transaction because it was all under Coldwell Banker, so it's all a dual agency situation. So that case went to the Court of Appeals. We didn't like the ruling in the Court of Appeals at all because it upheld Horiki's position. The Supreme Court recognized, and I think CR filed a front of the court brief, we're waiting for the oral argument. It has not even been scheduled. So we do not really know for sure if this case is going to be decided this year. It might be. It's kind of unlikely because we're already almost halfway through the year. But be aware, the courts are looking at dual agency, and there's going to be some changes. There very well may be some changes. Something's going to have to give. Either the court's going to decide, whammo, Sorry, if you're in the same brokerage, I don't care if you are on the other side of LA in a different office and you've never met your colleague, it's a dual agency and all that information has to be disclosed. Or maybe, I think what June Barlow, CAR's general counsel, is hoping for, we had a little brief chat about this in Sacramento, I think she's hoping that the court will carve out a different definition of dual agency. And that kind of makes sense to me, is let's not outlaw it entirely, but let's be reasonable. If I've got 75 agents here in Redondo Beach, and my same brokerage, I have 110 agents in Pasadena, why in the world would it be fair to have that information imputed from Redondo Beach to everybody in the office in Pasadena? Okay? So I'm kind of hoping that's where the court goes, but the legal basis for that, I don't know, they would have to make it up out of thin air. So we're all kind of holding our breath. It wasn't discussed in the Legal Affairs Forum our last two meetings because, frankly, there's nothing to say until the court speaks. But just be aware, particularly you're in large brokerages. I think there are a lot of general counsel of large brokerages that are going to be very much watching the oral argument and very much trying to anticipate how do we respond to whatever the court does. Again, I think it's probably going to be early next year. I originally thought it was going to be this year, but the Supreme Court doesn't seem to be in any rush. Yes, ma'am.
Regarding the full banker, full maker, doesn't it have to be the same broker?
Yes, same broker, right. But this is, right. So this is one broker that owned multiple offices. Yeah. And that's the problem, is we have many, many great guys and gals who own multiple offices. And are you kidding me? So out of all the offices, they're all supposed to have the Vulcan mind meld and know everything. So the only if the court decides that the appellate decision is going to be upheld, it may mean that you all have to do what we do already in the law profession, which is your large brokerages are going to have to develop databases on these properties and track any time any of their agents had any contact with a property. 10 years ago, you did a visual inspection. That's probably going to have to go in that database. So, because you never know when it's going to come up. Yes, in the back, sir.
My question is about a dual agency of one agent selling their own listing. Forget about the multiple offices. I've been doing this for a long time. I've never been able to figure out how an agent that has a listing can represent both sides of that transaction fairly. I just don't get it. I see it all the time. To me, it's greed. I've been doing this since 1980. I have never once done a double-ended transaction.
The question is, for those of you watching the recording, is how can somebody in a single transaction simultaneously personally represent both the buyer and the seller? He says, I don't do it. I haven't done it. And you raise an excellent point. And at the risk of alienating, 90% of the members of every association I work with, at least, that's the problem. Is, let me just, again, this is just in the backstage part of our website. This isn't going out to the general public, thank goodness. But truth be told, you have been in a battle. Your profession has been in a battle for many years now. The battle for your profession. Is this a profession or is it a trade? If it's a profession, people need to hire a realtor because you have unique experience and education and because you will fight for them. In a dual agency situation, you are prohibited from fighting for your client because you have two clients with opposite interests. Right? So I completely understand and sympathize with this problem. Is dual agency, particularly when you're simultaneously both sides of the transaction, you're basically telling both of them, well, I'm really not going to give you all the advice I can against the other side. I'm not going to try to get advantages for you or extra protections for you. I'm just going to sort of be the messenger. And I will tell you that about 2 years ago, when the Hariki case was just getting going, we in our meetings of Legal Affairs Forum are closed. It's just us attorneys. But somebody during one of these discussions spoke up and said, well, why don't we just do away with dual agency? Let's just do away with dual agency. And there was this pause. Because nobody wanted to follow up on that remark, because none of us wanted to have to switch to a different area of law because our clients would all hate us. But truth be told, it is a problem. It is an internal contradiction because, if you've seen all the signs from the last couple of directors' meetings, we have that, The realtor thing, the big blue letters were, what's it say, Jack? You know, who's your realtor? Who's your realtor? Okay. We want to convey to the general public that you shouldn't be buying properties off a website. Okay, that you shouldn't be buying it off eBay or Craigslist. There's a reason why you get all the education you do. It's to represent your client loyally and to the best of your abilities. And there is a contradiction when you're going to specifically say, okay, I'm really not going to do anything to take one side over the other. It's a problem. The answer is a harsh one. The answer and the answer this might be the beginning that we see from Haruki, because if the big brokerages aren't allowed to do this anymore without undertaking a horrific data responsibility in terms of conflict of interest, what does this mean for the rest of us? You know, I don't know. So I think the best outcome of Haruki would be that we carve out individual offices, but I don't know that there's any statutory basis for that. Yes?
If, in the large brokerages, they end up doing this large database to keep notes on properties, would there be the 3-year rule for saving data?
The question is, what happens if the Haruki case comes down against the real estate profession, and all of a sudden we have to start keeping conflict data? Does that mean we only have to keep it for 3 years? Oh, no. No, it's a disclosure issue. You know it. You can't just delete it. You'll have to save this for probably forever, because 10 years later, that roof leak is still a disclosure. You knew about that slope that had some slippage, you know, possible slippage. There's no statute of limitations on material disclosures.
If you sold property, and all your notes are in that file, and you're allowed 3 years later to destroy the file, where are those?
Yeah. So the question is, if we keep notes on a file and we're allowed to destroy our notes 3 years after the file, right, then what about that? That's the problem. That's the problem, is we have this knowledge, and it's going to be imputed to other people in the company. So that's why this could be a very, very onerous ruling if it comes down against us, and it very well might. Because, as I said, the public attitude about dual agency, and remember, who's deciding this case? Lawyers. And whenever people come to me and say, my brother and I have agreed that we want to sell this house, or my brother and I want to write up this contract to sell this house, will you help us write it up? The kind of disclosures that I make, you know, I'm required to have a specific acknowledgement that if at any point there's any disagreement, you know, I have to stop. Okay? There's very strict rules in the state bar on this stuff. And so these are the people that are deciding this case. So I don't know. I don't know if practicality or they'll transfer legal ethical standards. I don't know. But watch for it. It'll be breaking news. You'll have bulletins from CR. There'll be seminar. I'll be doing a seminar probably on a crash basis on what this means. Okay, probably at our broker breakfast or something like that. In the very back, ma'am.
Just to piggyback off what you said, so I get the point that after 3 years we have, you know, we're able to destroy the file and get rid of the paperwork. But isn't there, I think, a 10-year, isn't there like a statute of 10 years for people to bring claims?
Okay, so the question is, so we normally keep our records for 3 years and can throw them away. Well, how long do we have to keep them? And wait a minute, I thought there was a 10-year statute of limitations to make claims. Actually, that's a wonderful transition. And the last thing I wanted to cover that's not on the outline, the answer is, if you have material information about a property that would affect the buyer's decision to buy at that price, there is no statute limit, there's no expiration date on that information. We have a statute that talks about disclosure of death. Okay, so that we have a specific statute that protects us. But let's say we have a hillside slippage, or a foundation crack, or earthquake damage, and it was 20 years ago in Northridge earthquake, and 20 years later we have that information. That's still material information that we have that a buyer would want to know. So no, there's no expiration date. Now let me tell you what the 10 years does apply to. Many of you may remember that a long time ago with construction defects, we had basically 10 years to sue for any problems with construction from the time it was done. 10 years after it was substantially complete, and that definition had a couple of, wiggle rooms. That was it. No more lawsuits for roof leaks or slipping slopes or what have you. In 2003, that all changed with a law called SB 800. SB 800, and I've said this publicly, so it was an anti-consumer law. It was billed as the right to repair law. It has proved to be a total failure. The idea was that we were going to have some alternate system of justice for new residences built for the first time and sold for the first time 2003 or later. And what it did was it took that very simple 10 years to sue rule, and again, this is just on new residences. Commercial, repair, construction is still under the 10-year rule. But for new homes, new condos, new single-family detached homes, you had different years to file claims. Like, for example, you had 4 years to sue for electrical or plumbing. You had 2 years to sue for paint. You had 1 year to sue for certain, like sound. It was crazy. And so they shortened all these times to sue. And the whole selling point of the bill was, the whole sales job on the legislature was, well, builders should have the opportunity to come back to a property before a lawsuit happens and fix it. Because isn't that what we all want? We want homes to be fixed. And so that was the come on. Well, in 13, I actually presented a seminar on this in the Legal Affairs Forum about a year and a half ago with another lawyer who's a developer lawyer from Northern California. And, it hasn't worked. I still to this day cannot find one situation where a developer used their right under the right to repair law and went ahead and fixed somebody's roof without needing a lawsuit. So, and if we had more time, I'd love to go into that. Maybe some future seminar, we'll spend about 15 minutes on this. But the reason I bring all this up is this, is that two cases, okay, so we have the separate system of justice for residential new homes defects. So the question that we lawyers all had was, does that mean that the traditional 10-year rule is completely gone? Or is this an optional additional set of laws that may apply to when you have a roof leak, for example? The one court case about 5 years ago, I think it was called Liberty Mutual, and another case out of Santa Monica called Birch, B-U-R-C-H. They both held that no, this is not a sole remedy, that a homeowner who has defects in construction can sue for the SB 800 right to repair law, or they can use the traditional 10-year rule that we've known our whole careers. So two different cases held that. So that was great. Okay, so consumers, it wasn't as much of a, I was going to use a pejorative, semi-crude word. It wasn't as much of a job on homeowners as maybe we all thought it was. Well, not so fast, because last year we had a case come down late in the year that for the first time held exactly the opposite. And it said, no, this was an appellate case, and it wasn't LA, it was a different appellate division, because we have several divisions throughout the state. This different division said, no, we are not saying that this is that there are two choices. This is the sole remedy. If you don't qualify under this statute, you have no case. So, for example, and this is a really common situation, it takes oftentimes 4, 5, or 6 years for bad plumbing to show up, because it takes that long for the leaks to accumulate, and you start realizing, uh-oh, these pipes are all rotting, okay, or they're wearing out from the inside. Well, under this court's opinion, 4 years and 1 day after you close escrow, I don't care how many leaks you have, you're done. So now we have a direct and this case said, we are aware of these other two cases and we disagree. Now, that means that the next stop for this issue is the California Supreme Court. So I am not aware if any cases have risen to the level of where the Supreme Court is going to address this issue yet. But in the next couple of years, I think we're going to find, finally, after 14, 15 years by that point of ambiguity, once and for all, the Supreme Court is going to tell us, do we still have the traditional 10 years to sue, or are we all stuck, and I think the word stuck is accurate, are we all stuck under this right to repair law? So that's coming, but it's not coming as soon as Horiki. The next big thing we all talk about is probably going to be Horiki, And the next thing after that, close on its heels, sometime I predict in 2017, will be the fair housing regulations. So in terms of things to keep on your radar, I think those are the two big things that are going to affect how you and I do what we do. So that's the end of my prepared remarks, and I'm happy to answer questions. And if you need to go and want to head out early, I won't be offended in the least. I appreciate you listening. Yes, in the very back. The question is that somebody has said that you cannot have a rental agreement executed electronically. I'm not sure if that's true or not. I haven't actually looked at that. I don't do landlord-tenant work. I sure can look into it and maybe write something on that for you. You may notice that I'm starting to do monthly legal reports for all of you. There was a really long article that you just got on mold. So maybe that'd be a good topic is to look into sort of unique aspects of landlord-tenant agreements. SBAR, South Bay has a couple of, this is kind of an inaugural thing for us. We've been doing the risk management intensive now for a while, the thing on Wednesday, but these sort of town hall legal updates from what's happening at the CAR directors meetings, this is the first one that we've done. We're going to do one of these each time after the directors meetings. And so the next time we'll do one of these will probably be November after the NAR law seminar and the CAR meetings in early October. But the other thing that we started about 3 months ago now, is I'm doing hopefully not too long legal articles just for you. They're posted on the website, I'm told, in backstage, so the general public can't get them. And I'm told they're being emailed to our members. So watch for those. I hope you find them useful. Yes, sir. Go ahead.
I have a question on the dual agency.
Okay.
The first example, agent number 1 is seeking the listing, but doesn't get it. They don't get it. And then
Right.
later down the road, his office mate gets the listing. So this law of imputed information is in effect. But the first agent never had an agency. So, but the law is still saying the
Right.
information is imputed, even though there was no agency
Right.
at the time.
So the question is, Realtor 1 seeks the listing on a property, doesn't get it. A few months later, Realtor 2 in the same brokerage does get the listing. The first person never had an agency created, right? Because they never got the listing. But see, this has nothing to do with agency. It has to do with disclosure. So you're walking down, you're walking down the street and you know that this particular house had a collapse. And 3 years later, you wind up getting that listing. Now, you got that knowledge not because of any agency, but you had that knowledge from whatever circumstance. Knowledge is knowledge, and your obligation to disclose it has nothing to do with how you acquired that information. So that's what's difficult about if we're going to hold these large brokerages that all of the 100, 150, 1,000 agents in that brokerage, all the knowledge is imputed up to the broker. And here's where it gets really ugly and then the knowledge is imputed back down to the other agent. That's the real problem I have, is that it's being imputed back down to somebody else, like in Horiki, in a completely different office. That doesn't seem fair to me, but like I said, I'm pretty pessimistic about the outcome. Yes?
Yeah, well, are they saying that, okay, are you supposed to report that to your broker? I mean, how is that information going to...
Great question. So how are we supposed to get this information so that the other agents even have a chance, right? Well, and that's the kind of thing we're going to have to start sorting out, is if I have information because I dealt with this property 2 years ago, and 3 years from now it sells again through somebody else in our office, which very well could happen, how does that other agent get the information I had? Because in the law world, we would have already had that showing up on our conflict software. But I don't think, do any of you have databases on properties of your past dealings? I've never heard of such a thing. I think it's coming. And I think Horiki, if it comes down the way I fear, I think that and the direction of the case law is going to push our brokers in that direction. Yes, ma'am. Yeah. Yeah, the question is this because they're just chipping away at dual agency? And as I think I said from the outset, I don't think that dual agency represents us well, and I don't think that there's a favorable attitude toward it. I just got to be honest. I don't think it. I know financially it can be really important for those of us working. I don't sell properties. I just have a license so I can vote at CAR. But
What percentage of us are in favor or against?
the question is, do I know what percentage of our members are in favor or against dual agency? I don't. I could hazard a guess though that probably the vast majority would vote with their wallets on this issue. Jack, did you have a comment?
I just say, when I was a role for a person office, we had a case where, okay, someone, we had one of our agents acted as an agent for a property that was sold in our company less than 3 years, and we wound up with a lawsuit with that. Because we felt like, what I did was I said, okay, every single property that we have had in the last 4 years before we burned it, we put on a database, and therefore, if we were involved with transactions with that property, I went back and told the agent, you're gonna have to pull that old file, if it wasn't yours, and just redistribute all the new was gonna be. Because there was no way we could protect ourselves with that. After 3 years, they, no, it's already been destroyed, we don't have that.
Okay.
But I could protect myself, and it's worked.
Right. So Jack was just describing, Jack Ferris was just commenting that for at least the 3-year time period, his office has created a database. The problem we have, though, Jack, is that for disclosure law and for breach of duty cases, there's no statute of limitations on my knowledge. When I Wednesday, if you're crazy enough to come back twice in 1 week and hear me some more, one of the seminars that's probably going to affect you the most is your visual inspection seminar. And some of you, I think, have attended that before in past years. One of the questions I'm always asked is, well, if I notice something next door, do I have to disclose it? And the answer I always give is, knowledge is knowledge. So whether you know it from 10 years ago or whether you know it because you were walking your dog and you saw the fire happen, you read the newspaper report, knowledge is knowledge. And our job in zealously representing our client is to give them all the knowledge that they need to have to make a good decision about that property. So yes, yes, ma'am.
You mentioned earlier the legal hotline.
Yes.
Is that
The legal hotline, oh my goodness, that's one of the best benefits you have from your dues in CAR, in addition to the legislative stuff. And by the way, I didn't wear my pin, but I am a silver bearer. I write my check for CR2, and all of you should as well. But the legal hotline is one of the best benefits you have. There is a free service at CR. There's a group of like 12 attorneys. I mean, it's a big crew in the office in LA taking calls statewide from our members. If you have a question about a property or a transaction, you call them, and of course they're not looking at the contracts, so their advice is going to be sort of general, but they'll give you the best advice they can, and they really try hard to keep up on things. I was invited about 2 years ago. Oh, I'll give them the number. Thank you. 2 years ago, they invited me to come teach the legal hotline staff on the unique aspects of HOA law. And as some of you know, I'm pretty much into that heavily too. And they really wanted to know so they could advise all of you better. Now, if you are the second person calling, they do keep records on the property address and the name. And so if the selling agent calls first and you're listing, they'll say, oh, I'm sorry, we have a conflict. Okay, that's code for you're the second person to call. Okay, so there's a group of us lawyers around the state. We have volunteered our time to be overflow callers, overflow call recipients. And so they will give you usually 3 names and from the referral panel, and we're all lawyers that support real estate. We all do not take cases against realtors and all that. And we had to go through a pretty extensive application process. And then we'll give you, 10, 15, 20 minutes of some general advice as best we can. That's a great service. And the telephone number, and thank you very much, sir, is 213, area code, 739-8282. 739-8282. That's a great benefit. And I'll take a few more questions, but as we start to wrap up, just one small commercial. A lot of times your clients are afraid to get legal advice because they think that they're opening up a vein, right? And they're just going to bleed money to the lawyer. So one of the things that a lot of law firms do, including mine, is I have a flat fee consult that I do. so that your client has an unusual thing in their contract. Maybe it's a non-CAR agreement, for example, and they want some legal advice, or they want to know about canceling the contract, and you know that you can't really advise them. A lot of us do flat fee consultations. So my office, we charge $500 for an hour and a quarter. That's a lot of money, but they're not obligated to me. You know, they leave the meeting, and I'm not taking their case and hiring me. But local lawyers do that too. Ask if they have a flat fee consultation. You're going to find a lot of lawyers are willing to do that, and that may help your clients be a little bit more willing to get the legal advice that they need, but they don't get because they're scared because they've never dealt with an attorney before. So just a little tip there. So thank you very much. I'm going to take a couple more questions. Yes, ma'am, in the front.
It's back to new construction.
New construction. Yes.
A couple of legal hotlines is a little unclear. So I was told that by law, new construction is supposed to come with 1 year fit and finish
Yes.
warranty and
Yes.
then the 10-year statute of limitations. We were countered out for new construction offer that they would not provide a 1 year fit and finish, but they're going to provide a home warranty through, buyer's choice of company.
Okay.
It's American, but that doesn't include like fit and finish.
Yes.
For 4 years.
So the question is that we have a transaction where the builder of the home, because this is a builder we've got to be talking about, the builder has refused to honor the 1 year fit and finish warranty that under the right to repair law is automatic. Okay, it's automatic. So what a lot of them do, but if you look at the contracts, here's one thing that the builders do to make themselves look better. And I represent builders, okay? The ones I represent are pretty much good guys, but I see all kinds, you know what I'm saying? And a lot of times what they'll do is they'll have customized contracts. They don't want to use the CR contract. You know why? Not because the CR contract's not adequate, but because there's not enough goodies in there to try to protect themselves from their customers. So what they do is they'll have these very long homeowner warranty provisions in there, and they'll make it sound like, oh, we're just amazing. Look at all the things we warrant. But what usually they're doing is they're just taking the automatic 1 year fit and finish warranty and a few other things and making it sound like they're giving the homeowner extra. Chances are they probably aren't. Chances are, if you look closely, you'll find that all they're really doing is reciting stuff that's already in the right to repair law. So fit and finish, by the way, doesn't mean a whole lot. Fit and finish has never been defined by a court of appeal, but I think most of us lawyers think paint smudges, a chipped tile, okay? Fit and finish is not roof leak or foundation problems, okay? Fit and finish is cosmetics. So it's not really a terribly valuable warranty.
So they take that out, and then all the doorknobs start falling off, and they're not
Yeah, well, if they violate the warranty within the time period, and if the buyer makes a demand in a timely fashion, then they trigger the warranty. The problem with the whole right to repair law, it was designed to reduce lawsuits, but in a way, it increases them because the shorter statute of limitation mean that when in doubt, sue. Because you're only going to have a couple of years, like I said, 4 years for electrical or plumbing. The 10-year is still in the right to repair law, but it's the catch-all. But if you look, electrical's got 4, plumbing's got 4, dry rot, I think, has 2. Certain types of irrigation and paint are 1 or 2 years. So it's a pretty anti-consumer law. So anyway, well, I appreciate the really energetic, great questions, and I appreciate you all being such a great audience, and I look forward to being here after the October meetings, and maybe we'll see some of you on Wednesday if you're glutton for more punishment. Thanks for coming.